Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. So one of those objections that you'll hear a lot of time on TV courtroom dramas is objection speculation, or sometimes objection to lack of personal knowledge. Well, those are objections in the mock trial world, but it's important for us to understand what they're really about and what they're not. So that's exactly what we're going to do in this video. We're going to go through the nitty-gritty of lack of personal knowledge and speculation objections and talk about three things. First, we're going to talk about when to make those objections. We're going to talk about when not to make those objections. And then finally, we're going to talk about how to make those objections to make sure you are set up for success the next time you enter a competition and are thinking in the back of your head, should I object to speculation? Should I object to lack of personal knowledge? Soon, you're going to be able to know the answer to that question. So, you ready to hop in? Let's do it. All right, starting out with when you should object to speculation or lack of personal knowledge. Now, both of those objections are very similar. In fact, they both come from the same rule, which is Rule 602 of the Federal Rules of Evidence. But there is a bit of a distinction between them, and that's what I want to go over right here as we talk about when you should object to speculation or lack of personal knowledge. I think we all understand that in a general sense, speculation and lack of personal knowledge is when a witness is talking about things that they don't really know about, that they can't really know about. And so here's the distinction between the two. When those alarm bells are going off in your head as a witness is talking about things that they're not really that sure about, that they don't really know, and you're saying, well, which of these two should I object to? Here's the filter you can run it through. Object to lack of personal knowledge if a witness is talking about things that they don't know at all. Object to speculation if a witness is talking about things they don't know for sure. Let me give you some examples of those differences. Something that I don't know at all is what happened at a party that I was not at. Something that I don't know at all is what my dad was up to today, because I have not talked to my dad today. Right? I don't know either of those things at all. I have no knowledge on those fronts. And because of that, if I were to get on the witness stand and talk about what my dad was up to today or what happened at a party that I wasn't at, the appropriate objection would be lack of personal knowledge, because I would be talking about things that I don't know at all. Speculation, if I'm talking about things I don't know for sure, here are some things. I might speculate that a friend of mine who has been distanced lately is mad at me or hates me for some reason. I might speculate that someone who was late for work every day for a week is lazy and is snoozing their alarm clock every morning and really needs to do better in the mornings. So both of those were assumptions. They were things that I was speculating. And I very well may be right about both of those things, but we don't know for sure. And that's what makes them speculation. Because yes, it's true that the guy who's been late every day for a week might have been lazy, might have been snoozing his alarm clock. But it's also possible that his wife has been sick, and so he's been having to take his kids to school every morning, and so as a result, just for this week, he's been late for work. Right? Do you see how that works? The friend who's been distant lately, I could speculate that the reason they've been being distant is that they're mad at me, but there could be an entirely another reason behind that. And because of those things, because we don't know for sure, that's why it's not allowed under Rule 602, and that's why it's speculation. So, when a witness is talking about something they don't know at all, that's lack of personal knowledge. When they're talking about something that they don't know for sure, something that could be right, something that may even be a good guess, that's speculation. Because again, it might seem right, but we don't know for sure, and that's what makes it speculation. So those are the scenarios when you should make the objection, when to object to speculation or lack of personal knowledge. Up next, let's talk about when not to object to speculation or lack of personal knowledge. There's really two main scenarios I want to give you to avoid making this objection during. Scenario number one is when an attorney on cross-examination, or on direct examination for that matter, is asking a witness a question, and the entire point of the question is to illustrate that the witness doesn't know something. All the time, attorneys will try to convince the jury of their side of the case by proving, hey, this guy doesn't really know what he's talking about. He doesn't know X, Y, or Z. Maybe you're cross-examining a policeman and you're pointing out he doesn't know when the crime occurred. He doesn't know what weapon was used, right? Those are big, important points. And so think about how silly it would look if an attorney is cross-examining a police officer and they say, officer, you don't know what murder weapon or what weapon was used to kill this person. And you stand up and say, objection, lack of personal knowledge. Well, duh. Right? Of course they don't have personal knowledge. That was the whole point of the question. I've seen a lot of attorneys make this mistake, and it's honestly like embarrassing. If you've done that before, don't feel bad. We've all made mistakes. I've made plenty of them. I can tell you about tons of embarrassing mistakes I made during my mock trial career, but don't do it anymore. If the whole point of the question is to show that someone doesn't know something, don't make the objection. The judge will probably roll their eyes and make you sit down. That's scenario number one. Scenario number two, where you don't need to object to lack of personal knowledge or speculation, is when a witness might technically be speculating in the sense of they're talking about something they don't know for sure, but there's a really darn good chance that they're right. So, for example, let's go back to my example from earlier about the friend who's mad at me, or the friend who's being distant being mad at me, right? That's something that I'm speculating on. I don't know for sure. And it's really hard to know what exactly is causing the friend to be distant from me, so we don't like that. But what if we had something that was a bit more of a sure thing? Like I go and I'm around the friend and they look at me and roll their eyes and walk the other way. And every time I walk up to them, they move to somewhere else. And I start talking to them and their face is getting red and they're clenching their fists and they're looking really angry, right? Don't you think at that point we would be able to rationally make the conclusion that they're mad at me? Right, with the first one, we were jumping to conclusions based on a little fact that we didn't know for sure. But with that scenario, the person who's avoiding me in public, who's walking away, can't we kind of make the conclusion that they're mad at me? And especially if it's written in the case that they are, in fact, mad at the person, why are we objecting to that? No one is actually going to disagree that the person who is avoiding me at a party and intentionally walking the other direction is mad at me. Every person on the planet would agree with the truth of that statement. So why in the world would we object to it? It's just gamesmanship. It's just an interruption for the sake of interruption. Don't object in that scenario. All right, so we've covered when you should object to lack of personal knowledge and speculation. We've covered when you shouldn't object to lack of personal knowledge and speculation. Finally, we're going to cover how to make those objections. But first, I want to let you know that my new book, Mock Trial Masterclass, is officially available on Amazon. Guys, if objections are something that you have a hard time with, which don't feel bad about that because literally everyone, including me when I started, has a hard time with objections, this book is packed with information on how to make objections well. There are entire chapters on objections themselves. There's an entire chapter on the rules of evidence, including lack of personal knowledge and speculation, and all the other ones like relevance, hearsay, improper character evidence, expert opinions. Right, this book is loaded with easy to understand, easy to access information about objections to help you stop feeling so stressed out about them and so overwhelmed and start getting you to the point where you can object and defend objections with confidence and, more importantly, start winning them consistently. If you apply the principles in this book, that's exactly what you'll do. So if you'd like to pick up a copy, you can click the link in the description on YouTube or in the show notes on podcast platforms to go buy one on Amazon. All right, how to make lack of personal knowledge and speculation objections. Now, I talk all the time in some of my other videos and in my book about the importance of returning to the rule, RTR, on objections. And yes, that is the most important part of objections, of arguing objections, of winning objections. But with lack of personal knowledge and speculation, it's not really necessary. Because if you were to stand up and defend one of these objections or make one of these objections by saying, Your Honor, Rule 602 says witnesses cannot talk about things that they don't know about. Well, duh, right? Of course witnesses can't talk about things that they don't know about. That's the whole point of you saying the phrase lack of personal knowledge. It gets the point across. So in that situation, the judge doesn't need you to give an explanation and you don't need to waste their time with one. So instead of the usual path I would tell you to take with an objection, here's what you can do. Stand up, say, objection, lack of personal knowledge. Again, you'd make that objection if they were talking about something they don't know at all. Or stand up and say objection, speculation, if they were talking about things that they don't know for sure, and stop talking. Right? Just those two phrases, objection, speculation, objection, lack of personal knowledge. That's all you need. Because the judge is going to understand exactly what you're talking about, exactly the objection that you're making, and then you'll leave the other side to scramble and try to explain why what they're doing isn't what you say they're doing. So all you need are two phrases, right? Objection, speculation, objection, lack of personal knowledge, and just be ready to fight if it comes back to you. Listen to what the other side says in their response to your objection, and be ready to defend against it when it comes back to you. If you can do that, and remember to follow the other rules we talked about in this video, you're going to set yourself up to really excel with these types of objections and start controlling the courtroom like a mock trial master.